Welcome to the Constitution Line by Line. I'm Senator Mike Lee. Today we're going to be talking about Article 1, Section 3, which discusses the Senate. The first clause of Article 1, Section 3 explains that senators will be chosen for 6-year terms. As originally written, it gave the power to choose U.S. senators to state legislators. That, of course, has been changed by the 17th Amendment, which was ratified in 1913. Ever since 1913, with the ratification of the 17th Amendment, U.S. senators have been chosen by popular elections in their respective states. Clause 2 of Article 1, Section 3 talks about the terms of U.S. senators. It set up staggered terms so that not every member of the Senate would be up for re-election every 2-year period. In other words, there's an election for representatives that occurs every 2 years. During that time, each of the 3 classes of U.S. senators were divided into 3 groups: Class 1, Class 2, and Class 3. A third of the Senate is up for re-election every 2 years. That way, it's a continuing body, and after each 2-year incremented election, you'll have a maximum of 1/3 of the Senate that might have lost their jobs. The third clause of Article 1, Section 3 talks about the minimum requirements to serve as a U.S. Senator. It makes clear that someone, in order to be chosen for the Senate, has to be at least 30 years old, has to have been a citizen of the United States for at least 9 years, and also has to be an inhabitant of the state that they want to represent. The fourth clause of Article 1, Section 3 makes clear that the Vice President of the United States will serve as the President of the United States Senate. It also makes clear that the Vice President of the United States, acting as President of the Senate, will not have a vote, except in circumstances where there is a tie in the Senate. At that point, the VP gets to come into the Senate and cast a vote. I've seen this happen a number of times where the Senate has seen that a tie was at least possible. The Vice President of the United States will be summoned, and he'll come in, sit in the chair, and if in fact we end up in a tie, the Vice President casts the tie-breaking vote. In the absence of that circumstance, while the Vice President has the authority to sit as the presiding officer at any given moment and can make procedural judgment calls on substantive matters, the Vice President doesn't get to cast a vote unless there is a tie in the Senate. The fifth clause of Article 1, Section 3 makes clear that the Senate will have the power to adopt its own rules and also to choose someone to serve as the President pro tempore, or the person who will preside in the Senate in the absence of the Vice President, who, as a matter of right under the Constitution, may preside at any moment he's in the chair, and also to choose other officers within the United States Senate. The sixth clause of Article 1, Section 3 gives the Senate the power to try all impeachments. We have to remember the distinction between impeaching an officer of the United States and removing a president of the United States. Think of the impeachment, which takes place in the House of Representatives and requires only a simple majority vote. Think of that as a charge or an accusation, or perhaps a set of civil claims. This is something that accuses the officer in question of some type of wrongdoing based on high crimes and misdemeanors. High crimes and misdemeanors is a term that refers to Old English tradition that acknowledged certain offenses against the state, against the body politic, as distinguished from something that might be a more private offense, a private matter. The term misdemeanor was used a little bit more broadly in common law England than it is today. And as a result of that, it just referred to a broad body of offenses that basically would be understood as synonymous with the term high crimes today. The Senate may not remove anyone from office in an impeachment trial without 2/3 of the senators voting for that removal, voting to convict that person of the offense impeached or charged by the House of Representatives. And this clause, Clause 6 of Article 1, Section 3, also makes clear that when the President of the United States has been impeached, the Chief Justice of the United States presides over the impeachment proceedings in the Senate. Clause 7 of Article 1, Section 3 makes clear that the power the Senate has in an impeachment trial extends no further than the disqualification of that person to hold future office, in addition to the removal of the officer in question from office. It doesn't extend further than that. And in fact, the person impeached and removed still stands potentially accountable for any civil or criminal charges or accusations that might be brought against him. So as we see, clauses 1 through 5 of Article 1, Section 3 are relatively straightforward. They're not terribly controversial. They pretty much do what they purport to do on their face. Clauses 6 and 7 of Article 1, Section 3, by contrast, are a little bit more open to different interpretations and a little bit more the focus of debates that have occurred in recent years and in recent decades. There is some dispute about what exactly it means to commit a high crime or misdemeanor, which is the basis, of course, for charging someone or impeaching them and then removing them, as this clause contemplates. There are those who believe that it requires the accusation of an actual criminal offense and of a particular type of criminal offense against the body politic. There are others who say that it means quite simply whatever a simple majority in the House of Representatives and 2/3 of the U.S. senators might think that it means. There's been a lot of discussion about this, and this is an interesting question from the standpoint that it's never going to be litigated in court. The Supreme Court of the United States is not ever going to decide this, nor is any other court in the United States competent to decide this issue. The United States Senate is ultimately the court of impeachment. It's the only court that has jurisdiction to decide these cases. So the Senate itself has to be the body determining what amounts to a high crime or misdemeanor, and whether that has been committed in the instance of any particular impeachment alleged. The American people expect that members of the United States Senate will do their duty, and in fact, the Constitution itself, Clause 6 of Article 1, Section 3, requires senators to take an oath up front, being sworn in sort of the same way that jurors are administered an oath at the beginning of a trial. It's our obligation to find the correct legal result and to do what we're supposed to do without regard to our own personal biases or our own personal interest. Now, this is different, obviously, than what happens in a civil or criminal courtroom, where you've got jurors who are typically excluded if they have any pre-existing familiarity with the parties at issue or very often even with the subject matter of the dispute. It is nonetheless incumbent upon us, through the oath that we take, to do impartial justice, to make sure that we're doing the right thing. That, as much as anything, accounts for the fact that we haven't seen the impeachment power thus far being used indiscriminately to remove a president of the United States without good cause. I mean, it's been attempted, but it hasn't succeeded. Thank you for joining me for another episode of the Constitution Line by Line. Today we've covered Article 1, Section 3. Please join us next time.